Hi, I'm Lisa K. Donner, along with Jeff Charles, Sarah Cowgill, Scott Cosenza, and Tim Donner. And this is the Conservative Five, Liberty Nation's online TV news program. It was 8-1 for free speech at the Supreme Court, with Justice Clarence Thomas as the lone dissenter in whether a cheerleader who sent a vulgar Snapchat could be punished by the school. 14-year-old Brandy Levy had a meltdown on Snapchat. Her school saw it and cut her from the cheerleading squad. Did they violate her free speech rights? The Supremes say yes. It appears the Supreme Court came to the rescue of Ms. Levy. Shocked, surprised, or par for the course? Here with all the skinny on the court is our own legal eagle, Scott Cosenza, Esquire. Enlighten us, Scott.
I would say buoyant, Lisa, is the proper mood for people who respect and honor and depend on our free speech rights. The Mahoney Area School District in Pennsylvania thought that the appropriate punishment for Brandy Levy for sending a expletive-laden Snapchat to her friends, by the way, not to school officials or to the community writ large, to her friends, was that she not only continued to not be on the varsity team, but for the following year, they're just going to cut her from the junior varsity squad as well. This thing for, honestly, I just have flashbacks to my own high school career, as they say. And just, I wouldn't let these people park my car, much less handle the affairs of a child. Can you imagine? This is how important it is to her. They think that's a good punishment. So anyway, the Snapchat that she made was filmed off school grounds, and then she hit the send button while she was off school grounds as well to her friends. So this wasn't a school activity or speech made on school grounds, which might have been relevant to the decision. The school thought that they could police her speech 24 hours a day. That's the implication of their argument. They got her while she's on campus, and when she's off campus, she doesn't have free speech either. I think it is really the only the only acceptable judgment in this case was to say that it's free speech. I'm seldom disappointed in Justice Thomas, but I am in this instance, and I think it's a great win for free speech that students can talk freely when they're off campus to their friends.
Jeff.
Yeah, I'm actually a little bit surprised to hear that Clarence Thomas dissented from this. I mean, it doesn't make sense. I mean, when we were younger, we talked trash about our teachers all the time. It happened on and off campus, but it would be unimaginable that I could say something in high school that I talked to my friends about when we're hanging out, at the arcade or whatever we were doing, and having the school being able to police us for that or be able to retaliate, because this came up as retaliation to me. So the fact that we're in a social media age right now doesn't, in my opinion, it doesn't change it. Whether or not what she said was right or wrong, the school should not have the right to crack down on her and to punish her and retaliate against her because she insulted a coach or what have you.
I can't even put my legal analysis hat on this, Jeff, because I agree with you 100%. And I just get like this rage of anger against these school officials who are trying to destroy the life. This 16-year-old girl, this cheerleading means everything to her. And so she's had one 30-minute or 30-second spout off cursing them. And this is how they were. I mean, honestly, it's like everything I hate about government schools. It's totally unacceptable.
All right. Next, we have to go to the only person on C5 who has been a cheerleader. Sarah?
Is that me?
Well, I wasn't. I was never a cheerleader.
Okay, I would have been. I did some stupid things in high school, and I was booted off the squad at one time for like a couple of days. But that's a whole nother story, and I'm not going to go into it. However,
oh wait, we want details.
You
have to check the statute of limitations first.
We're going to keep pressing you for the details until you provide them.
Yeah.
Details, please.
Let's stay on point today, guys. Let's stay on point. Okay.
We're on this point.
Yeah, no, it was temporary. It was a gross misunderstanding.
All right. So they suspended you for a little bit, but what's your take on
This is ridiculous. Oh my gosh. What you do outside of the school property is your own, if your parents want to punish you, take away your phone or your, car or your walkie-talkie, I don't know, whatever. If your parents want to do and force you to go, hey, why don't you apologize, or otherwise you're grounded for the rest of your life, that's fine. That's fine. That's an internal family thing. But when it comes to the school overreach of going outside the lines, and the lines are, when you're on school property, you follow the rules. When you're off of school property, you can drop the F-bomb and scream and yell all you want. And if your parents don't like that, that's the only authority you should have to answer to.
This is a follow-on to a case 51 years ago, 1969, which Scott's familiar with, Tinker versus Des Moines, which had the Supreme Court allowing students to wear black armbands to protest the Vietnam War. And their ruling was that students had not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. But disruptive speech, at least on school grounds, could be punished according to that court decision. This is a natural follow-on to it, saying, now, in the age of social media, which didn't exist when Tinker versus Des Moines went down, in the age of social media, what you put on there is now subject to everybody seeing it, things that they never could see or hear when we were in school. So what the court is doing, is, it seems to me, is providing the same protection in the era of social media that it did before that era in 1969.
Well, Levy's free speech case is only one of many decisions released by the High Court this week. Another interesting one is about the NCAA, but we are out of time. So surf on over to libertynation.com, where we have all you need to know about all the case.
Lisa, let me get the last word in and say the real villain in this case is the narc friend of Ms. Brandy Levy. This Snapchat was supposed to be deleted automatically after 24 hours. Her friend captured it and narked her out, showing it to school officials. We would never even have it except for that. So
are we in the age of social media? We're also in the age of screenshots.
Yeah, snitches get stitches in my world.
They sure do.
All righty, guys. Thank you, Scott, and thank you to the rest of our panel. That's it for our Conservative 5 panel today. Check out our other C5 shows and segments on your favorite video platform, YouTube, Vimeo, Rumble. We're on them all. As well, Liberty Nation has its own Roku channel where you can see all our TV productions. Thanks so much for tuning in, and remember to surf on over to libertynation.com. Sign up for our new member zone, just $29.99 for the entire year. This has been a production of libertynation.com, conservative news where truth matters.